Well, hello and welcome to our webcast today on managing termination of employment. You're with Lewis Izzo, the Managing Director for Sydney Workplace Relations, Australian Business Lawyers and Advisors, and with me today is Caitlin from our Newcastle Workplace Relations practice. Good to have you here, Caitlin.
Thank you for having me, Lewis.
I've dealt with a lot of whinging from Caitlin this morning about the traffic on the way down, but she's made it safe and sound to Sydney.
Happy to be
here. To talk to us today about managing termination of employment. And so we're very excited to have her here and to have all our guests online for what we hope to be an informative session on the variety of issues you need to consider when it comes to termination of employment. So what we're going to do is we're going to look at the various types of termination that occur to begin with and go through the grounds and how you can validly terminate in each of the different scenarios that often arise. Then Caitlin, I think, is going to talk a little bit about negotiated exits and how to perhaps end up in scenarios where arrangements are reached or settlements agreed for someone to go out amicably on the way out. And then I think just a little bit at the end, we'll talk a bit about unfair dismissal and general protections laws, about the framework, but much of the actual substance of the content we'll probably have covered already by then. We've got the iPad here, if you can see it, which means that we can take questions from you live and answer them on the run. So please send through your questions. And Caitlin has also gone through a number of the questions that we were given in advance, and we might deal with some of them as we go. So that's really the run sheet. So we might get started.
Sounds good.
Grounds for termination. So we're going to look at each of these types of grounds. We've broadly split them up into grounds that an employer initiates and grounds that an employee might initiate. And we're going to just take you through both what these kind of, just at a mechanical level, how these work, who initiates, what notice is required, etc. But then we're going to develop it a fair bit in terms of when you can do so validly and not risk exposure to liability, or what steps you might take that might give you exposure later on. So I'm going to hand over to Caitlin to kick us off, who's going to talk about termination on notice, and we'll start to talk about the different ways you might do that.
Thanks, Lewis. Appreciate it. So, look, ultimately, termination on notice is the most common basis for termination. It's what most of you would kind of use on at first and foremost, at first instance. And ultimately, it's a situation where you have termination on giving of notice or payment in lieu of notice. And you're going to be utilising a termination on notice in circumstances most likely when you're dealing with performance, misconduct, poor performance, interpersonal dealings, or general misconduct that doesn't get to that serious misconduct threshold. Now, ultimately, when you're talking about termination on notice, it's what I like to consider the lowest threshold of severity. We're not talking about serious misconduct, which is obviously going to warrant summary dismissal. We're talking about that conduct that is on the lower end of the spectrum, but obviously may also ultimately be objectively serious in its own right. Now, what that means is it's not sufficiently serious to jump to termination. We want to make sure that we have gone through sufficient steps to actually prevent you from going down the rabbit hole of, jumping to termination too quickly rather. We want to show a process of counselling and warnings. We want to ensure that we're actually going through a process of performance, counselling, warnings, and we want to actually show cause the employee and put the employee on notice that their employment is at risk. Now, I won't go into these few categories and those steps involved with performance and management and show cause, because we will touch on those a little bit shortly, Lewis. But ultimately, the goal here is just ensuring that we have a valid reason and we're ensuring that there is procedural fairness that is afforded to the employee throughout the process, so that ultimately you have a defensible basis to terminate. Now, if we can just jump to the next slide, here we're just touching on what actually termination on notice means. Now, all employees must be afforded notice of termination or payment in lieu under the National Employment Standards unless they are a casual employee, they've been employed for a fixed term, and that's a true fixed term that doesn't have a notice option within the contract. That's important to note because often what we do see is contracts which aren't really a true fixed term contract. Or ultimately, if someone is terminated for serious misconduct, which warrants summary dismissal, as I mentioned before. Now, the minimum period of employment obviously does range depending upon the employee's service. It goes from 1 to 4 weeks depending upon their service. However, if someone has been employed for 2 years and is over the age of 45 years old, they must be given an additional week's notice. So under the NES, you're looking at a max of 5 weeks' notice. Now, however, the thing that you do need to remember is that often in some cases, your contract of employment or an enterprise agreement that applies to the organisation and the applicable employee may actually provide an increased period of notice, which needs to be adhered to. And the interesting part about that is sometimes it's seen as a negative, an additional period of notice, but in some respects it can actually be utilised as a beneficial way for the organisation to retain employees and ultimately enable them to recruit employees that are going to hopefully stay with the organisation, and failing that, ultimately the employer has an extended period of, say, 3 months, 6 months, whatever it may be, to ultimately then recruit a replacement if ultimately recruitment may be challenging in the circumstances.
Yeah, and I think so the thing to just bear in mind is that when we are talking about the NES, it's the minimum, and then you have contractual entitlements on top.
Yeah.
I mean, one of the issues that still comes up from time to time is what happens when there is no notice period in someone's contract. And Caitlin, can you just walk us through that? What happens if you have an employee, yes, they're covered by the NES, but their contract is silent? What are the types of issues we're going to come across there?
We're going to run into an issue of reasonable notice laws, and as you know, of course, and ultimately the issue is when you've got a note, you're silent in the employment contract, and ultimately, as the law stands, it imputes a question as to whether there is an additional period above the NES, which ultimately be reasonable in the circumstances, and ultimately, you're going to have to comply with it. So, or bear mind to it. So, it's really important. We always encourage clients to have a notice period in the employment contracts that you're signing employees up to, because at least you then have the certainty of you can avoid the ambiguity of reasonable notice.
So for everyone's benefit, what that means is that if your contract is silent, what notice you need to provide is going to be subject to a range of considerations as to what a court might consider is reasonable in the circumstances. Look at someone's length of service, how easy it is for them to get another job, the extent to which they're senior in their position, expectations of mobility in terms of the industry, how common it is for the type of role they're performing to be available to be performed elsewhere. And all of these things, how long their service is, all of these things get ramped together and jumbled together to try and work out what would be reasonable for a person in that position. It can range anywhere from 4 weeks notice all the way up in the most serious cases to as much as 12 months notice. And the only way to get around all of that, as Caitlin said, is to ensure you include your own notice provision in the contract.
And ultimately, you don't want to put your fate in someone else's hands.
Well, that's the thing.
At least if you're going to decide to have a slightly more increased notice period above the NES, at least you've intended to do that and the business is comfortable with that and you've entered into that knowingly.
Yeah, precisely. So now we're going to talk about the different types of termination. I'll kick off on medical grounds and then we'll go from there. So you can terminate an employee's employment where they are not fit to perform the role. There are a variety of considerations to take into account for that type of termination. We are talking about a termination on notice because we're not talking about serious misconduct or other types of those exempt categories that don't require it, which Caitlin took you to before. So when we're talking about termination on medical grounds, you've got someone who's usually either not fit to attend work or not actually able to do the role that they've been engaged to do. In addition, you need to satisfy yourself to avoid either discrimination or unfair dismissal liability that not only is it that they're unwell, but they actually can't do what are the core or inherent requirements of the role. Now, not all requirements are inherent. What you're looking for are those that are fundamental to the role that the role cannot be performed without doing those inherent requirements. Additionally, you need to take all or ensure you've accommodated the employee in all reasonable ways by making reasonable adjustments for them. So is there anything you can do to adjust the role, vary it, give them additional resources, etc., to ensure that they can do the role safely? And finally, you must have consulted with them about all this and proposed what you are doing and obtained their feedback before moving to termination. So just in summary, what we're talking about is that they can't do the inherent requirements. You've exhausted all reasonable adjustments or accommodations. And on top, you've also ensured that you've spoken to them, provided them with your preliminary views and giving them the opportunity to respond. And we're going to talk about that notion of procedural fairness in a bit more detail when we get to unfair dismissals. Once you've done all those three things, you are in a position to terminate. But if you're going to have a valid reason, it can't just be your view that this person can't do the role. You are going to need to have medical evidence that justifies why it is that you say that the person's not fit. Moreover, that medical evidence does need to be somewhat recent, and this is an issue we sometimes come up against, that people might have stale or evidence that is no longer really relevant to the person's circumstances. You need medical evidence that says, well, this is the person that I've met, I've assessed, this is the role that I've been informed that they're performing, and presently they can't do it or they can't do these elements of it. You're going to want to have evidence about what the prognosis for recovery is there treatment that they can obtain in order to be in a position to become better sooner or faster, and so on and so forth. So that's what we're going to be looking for relatively quickly before we move to termination. Now, I think that's... Sorry.
I was just saying, and on that point, I mean, often the question we get asked from clients is, well, can we proceed on the basis of a standard medical certificate that we have? And often the question is, well, the answer is no, most likely depending on, what information is in that medical certificate. And as you stated, you want to really have that information pertaining to the prognosis in great detail. And unfortunately, as we know, the medical certificate standard nowadays really don't have that particulars. One question that we had come through before the webcast, Lewis, relates to personal leave and how much leave an employer is required to permit an employee to take prior to termination.
So employers are entitled to take all of their personal leave. The reality is that there are certain prohibitions when it comes to medical terminations. Those prohibitions state that if someone has an absence of less than 3 months, or the absence is longer than 3 months, but they still have personal annual leave available they're taking, then it is not permitted to terminate that person's employee, terminate that employee on account of their illness until all of that is exhausted. The other thing that you need to bear in mind when it comes to anyone on workers' compensation is that in different jurisdictions there are prohibitions on terminating because of the injury for a period. In New South Wales, it's 6 months. In Victoria, in Queensland, it's 12 months, I believe. Victoria, I think, is 12 months as well. And so you need to ensure, if you're terminating because of an injury that they've made a workers' comp claim for successfully, you actually observe that prohibition period.
Definitely.
And the big thing there, and the same is with the 3-month prohibition under the Fair Work Act, the day they move outside of that prohibition, that doesn't mean you can terminate with will and arbitrarily. You still need to go through the process that we talked about in terms of satisfying yourself they can't perform the role, looking at reasonable adjustments, etc. Now, the next one that I'm also going to tackle is performance-based termination. So in relation to terminating for performance, there's a few things that are expected in order to avoid unfair dismissal claims. If someone does not have access to unfair dismissal laws, then you have much greater liberty in terms of moving quickly, and you really need to just focus on these notice obligations.
Yes.
But if they have unfair dismissal access, what the Fair Work Commission will expect are a few things. One, the performance grounds and these concerns are sufficiently serious to demonstrate that the person really can't capably do the role. Two, they've been warned about this, they've been given caution that they need to improve, they've been given a reasonable opportunity to improve, and nevertheless that improvement has not occurred. 3, they've been given whatever training or other assistance that might be reasonably required in able to do that role. And after all of that, they simply can't do the role. And what that comes down to is a finding by the Commission that they don't have the capacity to do the role. And what the Fair Work Act talks about is you need a valid reason to terminate based on capacity or conduct. We're not talking about misconduct here. So it's about their capacity not being there. And you would only form that conclusion if they've been warned, if any training that's needed is being given, and they've been given that reasonable opportunity to improve. And this is when we first get to this critical process arrow. And if there's only one thing you take out of the webcast today, it is that whenever you're dealing with termination, you need to follow this process all the way from serious misconduct at the most serious end to performance, medical, misconduct terminations. They should all be following a process broadly along these lines, which is that firstly, you need to establish what it is that you're concerned about, whether it's poor performance or any other type of issue. You're going to put those concerns to the employee. You're going to give them an opportunity to respond. You're then going to make your findings. That is, they're not fit to do the role, or they, despite all of the training we've given, they're just simply incapable of performing at the level we need. And then once you've made those findings, you're going to communicate them to the employee and explain the proposed sanction that you're proposing to take, give them that opportunity to respond, and then implement your action. And as you'll see on that slide, it's very important that to the extent they request support person, that you give them the opportunity to have that, again, to avoid liability for unfair dismissal claims. And that process is effectively the same in any termination context, and a failure to afford it is likely to be the head start for any employee in a Fair Work Commission unfair dismissal case. So it's critically important that this gets followed in your performance-based terminations. And so having gone through that, I think, Caitlin, you're going to take us down to misconduct.
Yes. And look, I just touched on that just to say, if anything, I just add to that and say, put it in writing. Of course, yes. Because a lot of clients come to us and say, oh, we followed the process. But where's your documentation of it? And ultimately, the process is only so good as the evidence you have to corroborate the process you actually undertook. So you want to ensure that you're having documentation which supports the process you've undertaken, and that ultimately you can lean on in the event that you were to receive a claim down the track.
And sorry, actually, before we do move to that, we've got the classic question that arose, which is how many warnings do I need to give before terminating someone for performance? Caitlin, your views on that?
Well, look, I think it really depends on the circumstances personally, and the egregiousness of the conduct, and the relevant, as well, whether the person's in their probationary period as well, obviously. But I think the golden rule is always, in my mind, going to be 3.
Yeah, and I think that the reality that it doesn't mean that you have to do it in that circumstance, but you're not going to rashly terminate someone for performance after the first warning, for instance.
No.
And so you just need to ensure that there has been a reasonable opportunity to give that opportunity to improve, to be put on notice that actually it's still not acceptable, therefore move again and give another warning, etc. And the more you give, obviously, the better position you are. But there's no automatic rule as to what you can or can't do. But in most circumstances, you may well have a number of that nature. Now,
and misconduct. I was just going to say, sorry, before we do move on, one of the other questions that has come through, which I think is an interesting one, is where ultimately there has been a historic underperformance that's been unaddressed, how does that ultimately affect the ability to proceed to termination and undertake a PIP process, for example, where the conduct or the performance has not necessarily been addressed historically?
I mean, we get that all the time. The issue is there is nothing wrong with starting to address that performance and starting the process. The problem employers have is when that performance hasn't been addressed, when they finally come to addressing it, they actually want to move to termination immediately. And so you have this classic scenario of someone who's been engaged for a number of years, has been underperforming for a number of years, and then someone forms a view, oh, we need to terminate. Well, because you haven't managed it, you can't then just immediately move to termination. Yep. What you need to do is start the process afresh.
Definitely.
And once you've started that process, of course, you can then move to terminate in due course if they don't improve. Our difficulty with our clients is that with unaddressed performance, by the time they finally come to us, the patience has been lost to actually deal with it properly. And that's when you're probably talking about a negotiated exit, because the business doesn't have the patience it now needs to do it properly.
And the difficulty too is often, unfortunately, clients come to us wanting to rely on performance issues from 2 years ago. And unfortunately, a lot of the time, it's just really not appropriate to do so in a lot of circumstances, because ultimately the situation's changed, the person's performance has arguably improved. Obviously, it's unique to each situation, but you want to be refreshing, addressing the situation, moving forward with a performance improvement plan, but ultimately having regard to the conduct and the performance at that point in time.
Yes, absolutely.
All right, fabulous. So if we progress to misconduct now, ultimately the process with respect to termination on misconduct grounds, in my opinion, is quite semi-similar to the performance grounds that Lewis has just taken us through. So I won't labour on it too much, but ultimately what you need to consider when it comes to misconduct is ultimately, what is the conduct? How serious is it? Does it get to that serious misconduct threshold that will amount to summary dismissal that we'll talk through in a minute? Or ultimately, is it on the lower end of the spectrum? If it is on the lower end of the spectrum, you really do want to be ensuring that you are giving multiple warnings, give people an opportunity to improve, giving them that training, because ultimately, a lot of the time what we do find is clients come to us saying, oh, well, actually, we haven't given our clients, our employees rather, training on what employment expectations are around conduct, but they should have known. And ultimately, that's, in the eyes of the Commission, not really good enough. The Commission wants to be able to see that you've set expectations, that everyone's on the same playing field with respect to knowledge of those expectations, and that to the extent that there has been any deficiencies in relation to an employee's conduct, that they're being put on notice about them and given an opportunity to improve. Now, the key difference, in my opinion, when it comes to misconduct and performance is, of course, obviously, performance is slightly different in the way that it's characterised. Misconduct, ultimately, sometimes there will be quite overt conduct that's observed and it's not in dispute. But more often than not, you're in a situation where there is actually a dispute of fact as to whether the conduct that has been alleged has in fact occurred. And to the extent that happens, ultimately what you're going to be doing is undertaking an investigation before you even ultimately undertake the warning, show cause and dismissal process. Now, we won't delve into investigations too much, because ultimately we could be here for a whole hour on investigations, if not a day. But ultimately you're going to be undertaking an investigation where there is a dispute of fact and where ultimately you need to make some findings as to what actually occurred, having regard to what the complainant, respondent, and ultimately witnesses who were potentially involved in the conduct have observed. Now, once you make those findings, ultimately there would be a warning process. To the extent that the employee has not exhausted kind of their warnings, then you go through the show cause process that Lewis has already touched on before we get to dismissal. And ultimately, the goal here is just ensuring that, one, procedural fairness has been adhered to. We're still making sure that we're going back to that arrow. We're offering a support person. We're ensuring that the employee has been given an opportunity to respond. They're sufficiently on notice of what the allegations are against them. A lot of the time, Lewis, I know you've probably called me a number of times about this. We have clients who come and say, oh, well, I put the allegation in a roundabout way to the employee. And in my mind, that's just not good enough, because ultimately the employee, if their employment is at risk or they're at risk of disciplinary action, ultimately the employee needs to be sufficiently on notice in specific terms what the conduct is that they've been alleged to have undertaken.
That's right. And so that's all about them having the reasonable opportunity to respond. And a failure to do that, it just infects the process, and then you end up with exposure to liability. Now, we've had a couple of questions come through, so we might deal with them now. The first one is an employee refuses to work out their notice period, what is the recourse? Do you want to help us out, Caitlin?
Well, ultimately, you can negotiate, obviously, to finish someone up early. That's in my view, the preferred course of action. Ultimately, if someone doesn't provide sufficient notice, and we do touch on this a little bit as it pertains to resignation, most modern awards do actually restrict your ability to actually not pay an employee their statutory notice. So you can, if an employee is over 18 years old, most modern awards do provide you the right to reduce their notice period by 1 week. But ultimately,
if they're not working, you don't have to pay them the notice period,
yes.
but you can deduct up to a week's pay under the award. But I suppose the issue with anything like that is you do need to be careful that you are deducting under the award, because if you don't have that award right, then you can't really, under the Fair Work Act, make deductions. So you do have this distinction between award-covered employees who do have this penal provision effectively, which says that if they finish up early, many awards will give the employer an opportunity to deduct up to 1 week's pay from them. Employees who aren't subject to the award because they're on an EA or a contract of employment, generally there's no deduction, right? If they've stopped working, well, you don't have to pay for the remainder of the period, but you can't deduct anything else.
Yes.
The other thing about them stopping working, though, is, and this happens a lot in terms of employees in highly competitive industries, sales employees, is that doesn't necessarily mean that they can just go and work somewhere else immediately.
Yes.
You can hold them to the notice period in two ways. One, if push comes to shove, you can actually threaten legal proceedings to stop them working elsewhere whilst they're still under notice with the old employer. And alternatively, if they actually cause loss to the employer, that is, the departure early has resulted in some event arising where the employer is actually losing significant sums because of the failure of the employee to work, they can actually be subject to a claim for damages, for breach of contract, for not following the correct termination procedure, and the employer can theoretically sue for that. Doesn't happen very often, to be honest.
It's a limited cost benefit depending on what the quantum is, of course.
But it's theoretically available. So that's termination on misconduct grounds. I think we're Caitlin, you're going to take us through summary dismissal, I think.
Yes. So ultimately, as I've mentioned a few times before, summary dismissal is a situation where ultimately you're going to proceed to terminate someone in circumstances of serious misconduct. It's a very high bar. It's the threshold obviously above misconduct. And when you're looking at serious misconduct, the benefit is obviously you don't have to pay notice. However, I always counsel clients to really consider in detail whether the conduct is of itself sufficiently serious to warrant serious misconduct. And the reason for that is the law essentially says it's your most egregious, serious conduct. And when we're talking about physical violence, fraud, theft, series of harassment, bullying incidences, as well as serious breaches of WHS, now, realistically, they're pretty high bars in my mind. And a lot of clients will kind of jump to that conclusion pretty quickly. And in my mind, a lot of the key reason people try and do that is because ultimately some of the procedural elements that we usually adhere to when it comes to termination on misconduct grounds fall away when you've got a serious misconduct.
And by that, you're referring to warnings and things like that.
Yes. So ultimately, if the conduct is sufficiently serious, you're going to have a instant dismissal in a sense, and you're not going to have to go through the procedural fairness in as much of a detail. However, ultimately, in a lot of respects, you still need to be mindful of those.
You're still going to have to, and this is the thing, and this is the nuance about procedure in a way. There's no requirement for people to have been warned and those things when dismissing for serious misconduct, but you still do need to actually put the allegations to them.
Exactly.
And you still do need to follow the requirements of the process arrow, because at the end of the day, what this is all about is about the employee understanding what the allegation is against them and having an opportunity to respond, so you get the right decision at the end. Because if you don't actually accord procedural fairness, not only is that a ground that can give rise to unfair dismissal liability even for serious misconduct? But it just means that you're starting to put at risk whether you're going to arrive at the right outcome. The whole point of procedural fairness is to give you all the necessary information you need so that you can then make the correct decision. So in terms of what you get out of, yes, you don't necessarily have warnings and those types of things, but you still do need to put allegations to people and have them respond. And a failure to do so is certainly extremely risky in terms of getting the wrong outcome or facing unfair dismissal liability.
And if anything, Lewis, I'd say it's actually more important in the instance of serious misconduct to make sure you're going through the back end of that arrow, because you're actually there's not a pattern of performance or a pattern of misconduct that demonstrates what's been happening. It's most likely in a lot of situations it's an isolated incident, and if you're jumping to that termination too quickly, you're not giving the employee an opportunity to demonstrate what actually happened. Most of the time, obviously, you want to proceed with an investigation to the extent that there is a dispute of fact. Obviously, if there is no dispute of fact, then that's not necessarily always necessary. But if you don't go through those processes, in my mind, the Commission actually looks more harshly upon you when it comes to characterising something as serious misconduct.
And so dealing with a couple of questions, one of the questions we've had is it necessary to provide employees with copies of witness statements when presenting allegations to them? How do you address this? And look, this comes up often. You do not need to necessarily provide someone with witness statements or with detailed, the actual content of complaints. If you go back to that process arrow that we've put up a number of times now, the notion of procedural fairness does not require, you won't see their witness statement, you won't see the formal complaint there. What it requires is the employee to be given the allegation. They need to have the alleged facts put to them in a level of specific detail so that they can respond. That is what is more often than not necessary. In some instances, being given a fair opportunity to respond may require them to understand that the identity of complainants or potential witnesses, if there is some suggestion that there are people with alternative agendas or some bad faith. It may be in some circumstances that the employee does need to know to properly respond. But in most cases, what's more important is that the allegation is put to the employee, not what statement it was that someone gave.
And if anything, I would actually also argue in a lot of respects, putting the allegation in a specific way to the actual respondent to the allegations is actually more important, because often we see employees raise complaints that aren't articulated in a way that an employee can actually respond to.
Yeah, no, agree. And look, two final things on summary dismissal. We did have a question in advance. How do I know whether the conduct is sufficiently serious to constitute serious misconduct? I think there's two things I'd like to say about that. The first is generally for conduct to be serious misconduct, it needs to be inconsistent with the continuation of the employment relationship. That is, it is such an egregious breach of contract that the party that was engaged in it is effectively, the conclusion is they no longer intend to be bound by their contract. Yep. And that's why you had those examples given by Caitlin of fraud and theft, etc. The other one to bear in mind is that there has now been an amendment to the Fair Work Act to specifically define sexual harassment as serious misconduct. So any act of sexual harassment in breach of sexual harassment laws itself does automatically constitute serious misconduct. But we'll talk a little bit more about how that then feeds into unfair dismissal laws and whether someone could still be dismissed and still face exposure to liability in that regard. The next way in which an employer might terminate is redundancy. There's only three things to really be mindful of when it comes to redundancy. And again, we're talking about two types of employees here, those with unfair dismissal access, those without. If we start with those without, the considerations are far less. The real question is whether, if it's a genuine redundancy, you need to pay redundancy pay, but otherwise you'll be complying with your notice provisions in your contract of employment. If someone is covered by unfair dismissal laws, though, there are three primary considerations. To constitute a genuine redundancy, the person's job must no longer be required to be performed by anyone because of changes in the operational requirements of the employer's enterprise. Two, the employer must have complied with all consultation obligations that pertain to the employee, whether they arise under an award or an enterprise agreement. You must have honoured all consultation obligations. And remember, that involves things like putting all information in writing to the employee about the nature of the changes, steps to mitigate the changes, explaining the effects of the change to the employee. So all of that needs to be complied with. And three, then it must have been, sorry, I'll withdraw that. Three, you must have exhausted all reasonable redeployment opportunities for the employee before moving to termination. And so when we talk about a genuine redundancy, in order to avoid exposure for unfair dismissal laws, you need all three of those requirements. No longer require the job to be performed, you've consulted, and it wasn't reasonable to redeploy. Now, if you have complied with all of those three requirements, then there is an exemption to unfair dismissal laws, and so you're not looking down the barrel of an expensive claim. Well, you might have a claim, but at least you've got a defence to it.
Exactly, and you've actually genuinely engaged with each of those steps as well, and you've got a nice paper trail of all of that. It would be the other thing that I'd add. A lot of clients try and do a tick-the-box consultation exercise, and particularly under the modern awards, they really do set out a quite specific process that needs to be adhered to. So it needs to be genuine, it needs to be engaged with, and ultimately needs to comply with the industrial instruments.
Resignation.
So ultimately, resignation, of course, as we all know, is a situation where an employee is actually going to terminate the employment at their initiative. Now, the thing that we need to take into account with resignation, in my opinion, is that ultimately it's not without its risk. A lot of people say, okay, well, employees resigned, happy days, wash our hands, everything's great. The question it comes to, okay, well, is it actually a genuine resignation? We've had lots of clients questions come through in relation to constructive dismissal and what that means. And ultimately, constructive dismissal comes down to a question of whether the resignation was in fact voluntary, and ultimately whether the employee was in a way pressured or had no other choice but to resign. Now, ultimately what that comes down to is obviously the factual situation, which will be dependent upon the circumstances in each individual employee. But the things I counsel employees to clients to really consider in this respect is not just accepting a resignation, Lewis, but actually speaking to the employee and actually discussing it. Why are they resigning? Getting that in writing so that they actually can satisfy themselves that it's a genuine resignation that has been actually reflected in writing, so that we have a record of that in the event, or the unfortunate event rather, that employee was to make, for example, make an unfair dismissal claim and assert that they were constructively dismissed and that they only resigned because they felt like they had no other choice. Now, the next, I guess, question we've had come through in relation to this is, well, how do we safeguard against constructive dismissal? Is there anything else that you would add to what I've said, Lewis, around constructive dismissal?
I think there's two elements to this. I mean, you've already outlined the test for a constructive dismissal, which is so the person, due to conduct of the employer or at the employer's enterprise, the set of circumstances arose that such that they had no choice but to resign. Now, that's quite a high bar. It's very difficult to think of steps that actively prevent it other than complying with all your usual safety and respect at work obligations. I think the piece about ensuring you get something in writing is important for two reasons. The first is, at least at that point in time, the employee is identifying that they've elected to resign, and whatever they put in writing at that point in time will be helpful to at least testing factually why it is they left and all of those things. And if they don't actually say much at that time, that itself can be of assistance when we come to arguing about whether they had any choice later on. The second element is, as well, if we move aside from constructive dismissal for a moment, that on occasion employers will resign and then seek to retract the resignation later. If it has been put in writing, clearly specifying when they're resigning, when they intend to leave from, when the effective date of termination is, then that makes it much, much more difficult for them to retract that on the basis that it's a resignation in the heat of the moment later on. And so that's why it's always preferable to get some form of written communication. The reality is that once they do resign, they have to provide you the notice, and we've talked about that before. We've had a number of issues recently with employers wanting to bring the notice period forward. You really need to be careful before doing that for this reason. If an employee resigns with 4 weeks' notice or with 3 months' notice, they are voluntarily leaving in 4 weeks' time or in 3 months' time. If you then change that and say, well, no, we're paying you out, we're going to have you leave today or tomorrow, what you're actually doing is flipping the termination from a voluntary one by the employee to now an involuntary termination, that is a termination by the employer on an earlier date. And what that can really give rise to is exposure to unfair dismissal liability, because the employee may allege that there's some loss that they've suffered. And so it can also give rise to general protections exposures, because all of a sudden the whole gamut of adverse action and other discrimination type claims associated with dismissal can be enlivened, because it was no longer a resignation in 3 months' time, but a dismissal by bringing it forward. And so you need to be very careful in relation to that type of scenario with bringing terminations forward.
Just to interject there, just playing devil's advocate, I'm sure we've probably got people coming through with questions about this. Say, I'm paying pay in lieu of notice. Surely that can't be disadvantage. What would you say to that?
Well, the reality is you are paying in lieu of notice, and so as a result, their notice period, if it's the same amount, it may be that they haven't suffered much loss. But what it does do is it still opens up the claim for loss. So if for some reason they say they've suffered other loss as a result of a decision to bring them out of the workforce 3 months 3 months earlier, they could certainly bring a claim associated with that. For instance, if not being employed has some license implications for employers that operate with particular licenses, but more generally, particularly when we get to the constructive dismissal argument, if all of a sudden they're saying things like, well, I was forced out, I was pushed out, they give this resignation, you then in any event flip and say you're out straight away, it all starts to build a framework. Well, actually you have ended their employment, and then you lose your ability to resist, as I said, adverse action claims, discrimination claims based on dismissal, because you actually have dismissed.
Yeah. And the other points I'd make when it comes to characterisation of potential loss, things like leave, things like bonuses.
That's true.
Ultimately, if you're bringing the employment forward, the conclusion of the employment forward, ultimately a lot of employees may be missing out on a bonus. They may be, if it's an extended notice period, ultimately there's probably some annual leave that would, but for bringing the employment forward, they would have been crystallised during that period.
Agreed. Now, another question that's come up is whether it's necessary to accept the resignation in writing. The answer to that is no, it is not. But although you don't have to accept a resignation, for the very reasons we gave earlier, if there isn't this kind of clear meeting of the minds that, yes, you've resigned, yes, okay, this is your last date. If you don't do that, then the issue is that, one, you have a prospect that the employee may seek to retract or change the character of what it is that occurred previously. And two, there's just a bit of ambiguity about, well, what are the final dates? When is it that we're going to finish up and that I need your equipment from you and you need to ensure that you're kind of off the system and completely disconnected from work? So it's just kind of best practice, really.
If anything, it's polite, I'd say.
That's right. Now, the next, we're getting a few questions and we'll just keep rolling through them. If an employee resigns during a procedurally fair disciplinary process, is the business liable for an unfair dismissal claim? Look, my short answer to that is no. If you are conducting a disciplinary process and the person resigns during it, that type of action is not, in my view, something that would ordinarily leave an employee with no choice but to leave. That type of disciplinary process is normal managerial conduct. And provided it's being conducted in a reasonable, impartial manner, dispassionate, without kind of any improper behaviour, by an employer, then the fact that someone has left is not itself any ground for a dismissal claim. And what you should be relying on is this was a resignation. But this feeds back to your question before, and that's a good example of this is the very reason why you don't then want to just pay out a period in lieu. And because all of a sudden someone says, oh, well, I resigned during the process, but it's because I felt forced out. And all of a sudden, when they resign, you then pay out the rest of the notice. All of a sudden, what you'll find is they actually do have a dismissal claim because technically it was a dismissal, and then all of a sudden you have arguments about what was their loss. And you just want to have the resignation as a complete bar to a matter proceeding. So that's resignation. I think abandonment of employment rests with me. I hate this topic.
It's a funny one, isn't it?
And the reason I hate this topic is because it is so misunderstood. The reality is that abandonment as a concept in practice had a lot to do a long time ago with shortcuts to exit. It's much more difficult now. Really, what an abandonment represents is an indication by an employee that they no longer intend to be bound by their contract of employment. And once you have reached that state of satisfaction that they no longer intend to be bound, you're effectively terminating the contract, you're terminating the employment in response to what we describe as their repudiation, their demonstration of no longer wishing to perform the services. There's a few things about that. One, in order to be satisfied that someone no longer intends to be bound by their obligations, that is quite a significant threshold to reach. That is a satisfaction about quite a significant state of affairs. You should be making significant attempts to contact an employee. And again, people have these rules about, oh, well, as long as you've reached out once or sent 2 letters, then it's fine. The reality is you should be making all reasonable attempts to find out where they are, where they've gone, why they're not responding.
Are they okay?
Are they okay? I mean, anyone who wants to terminate for abandonment in a period of less than a week, I would say is dreaming, because surely you're going to take some measures to try and find out where this person is. It might be a bit different if someone storms off on a Monday and says, I'm never coming back here. I've had it. I'm going overseas and not coming back tomorrow. And then you spend a few days trying to find them and it's clear they've gone overseas. That might be different. But generally speaking, you're going to send several letters, different types of communications, text, phone, last known address, next of kin, all of those things to try and find where they are. Once you've satisfied yourself they don't have any intention of returning, it's at that point that you will be sending them a letter proposing what you're going to do, that you're not, that you're of the view, the preliminary view, that this person no longer intends to be bound by their terms of employment, that they're abandoning, waiting a reasonable period of time for them to respond, and then ending the employment on that basis.
And putting them on notice. It comes back to that procedural fairness arrow.
That's right.
Putting them on notice that this is a possibility. But ultimately, obviously, if you can't get in touch with someone, it is unfortunately sometimes a step you need to take.
Yeah, that's right. And once you have done all of that, when you do ultimately terminate, the standing commission case law is that you won't have to provide notice of termination, because what you are doing is effectively accepting their repudiation of the contract. And so it's not a termination of the relationship by you. It's at their initiative as opposed to the employer's. So we've run fairly extensively through our time, but we've got about 10 minutes left. Caitlin, do you want to take us through this concept of negotiated exit? Before you do, just to frame it up, we had a question from someone that doesn't require immediate response, but it'll help frame the background for the discussion. Jacob asks, what is a negotiated exit? Isn't that risky? Well, Caitlin, can you take us through the negotiated exit and help us avoid the risks, or at least tell us what they are?
Well, Jacob, the answer is it can be if it's not done right. Look, ultimately, a negotiated exit is a situation where there's a mutual agreement between the employee and the employer that ultimately the employment is going to cease, and the terms around that. Now, ultimately, when it comes to negotiated exits. Lewis and I were having a chat about this on the way here, and what we find is that people jump into negotiated exits a little bit too hastily. You really want to proceed with a negotiated exit where there is a dispute between the parties, and also where it's being phrased and put forward as a genuine without prejudice offer. Now, what that means is ultimately that the offer is, quote, off the record, but also that and in order to do that, there needs to be a genuine dispute between the parties that can be relied upon. We don't want to jump to it too early, because obviously there does need to be a dispute, but moreover, practically speaking, what I find clients do too often is they jump to the process of wanting to negotiate an exit with an employee because, for example, there's been some historic underperformance, conduct, whatever it may be, that they don't want to go through the process of issuing warnings. Ultimately, they feel as though the relationship is irreparably damaged in some way, and they feel as though the employee is going to accept a negotiated exit. And I completely appreciate why people kind of think, oh, all right, let's try and get them out, let's make it mutual. But if there's not a dispute on foot, there's a genuine question as to whether it is a without prejudice offer, and also whether the deed in some respects can be enforceable. But moreover, acceptance is never guaranteed. And if there's no dispute on foot, you haven't advanced the process sufficiently that there's writing on the wall and the employee actually understands that their employment is potentially going to be terminated, but for there being a meeting of the minds and a negotiated exit being reached. So I think it's really important to ensure that you are doing it at the appropriate time, not doing it too early, and also, most importantly, ensuring that your documentation is up to scratch, because a negotiated exit is only also so good as it's enforceable, and your documentation is sufficiently and comprehensively prepared.
Yes, I think there's a few things here. So the first thing is, when you're in a disciplinary process, it's important to have the formal process commenced first. So that generates disagreement between the parties of some kind. And it's at that point that you would look to have a discussion and say, look, I'd like to have a without prejudice discussion with you. And you need to explain what that means. That's confidential. The parties can't use what is said in that conversation later on in any proceedings or dispute. And that it is genuinely an attempt to resolve a dispute of issues between you. That's what sets up the without prejudice kind of umbrella. The reason you're doing that is so then if ultimately there isn't acceptance, as Caitlin pointed out, and someone gets dismissed, that you're trying to maximise your ability to not allow that type of discussion into evidence later on. And the only way you do that is if it's genuinely confidential, we've agreed, neither of us are going to rely on this conversation later on as to resolve a dispute between us. That's what has a without prejudice character. And it's important you use the word without prejudice. You use that phrase, but you need to explain what it means and ascertain that the person is willing to have that type of conversation. If you do that and you then have a discussion about them leaving amicably with some payment, perhaps before the disciplinary process is concluded, that is fine. It doesn't guarantee that some of this might not end up in evidence in a proceeding later on, but it does maximise your ability to prevent these types of evidence coming in. So that is, you're minimising exposure, but you're not guaranteeing that it won't appear later on. And as Caitlin mentioned as well, doing it in that way also maximises the enforceability of the deed of release. And that's why we kind of, to answer Jacob's question, there is no way to do all of that with complete safety, that what you've discussed won't come out later. But often employers are attracted to it as a practical means of trying to move people on without going through a full disciplinary process for one reason or another.
And it's a nice commercial way to resolve a situation, but ultimately it's not without its risks. And moreover, I just counsel people, be careful what you're saying without prejudice conversations. A lot of people think, okay, look, it's off the record, I can say what I want. And unfortunately, that tends to come back and bite you in the bottom.
Now, so what we've done is tried to talk about most of these issues in advance. So I'm just going to move through unfair dismissal quite briefly. The reality is, for certain categories of employees, they have a protection from unfair dismissal. That is, they can't be dismissed in circumstances that are harsh, unjust, or unreasonable. At the outset, the people that have access to this type of protection need to have worked for more than 6 months, and they need to be earning less than $162,000 a year. So they're your two primary determinants: more than 6 months employment, less than 162,000. Now, there's a few variations on that. If you're a small business employer with less than 15 employees, actually there's a 12-month window before unfair dismissal laws apply. And equally, for all employees, if they're earning more than 162,000, but they're covered by an agreement, enterprise agreement, or a modern award, then they still have access to unfair dismissal laws. But most employees, 162,000 will be the threshold that either determines whether they're in or out of the jurisdiction. And so once we've looked at that, people have access to unfair dismissal laws, and the Commission will consider whether there's a valid reason for termination based on conduct or capacity, effectively, is what the Act talks about. So has there been some conduct issue or capacity issue? And performance really feeds into capacity to do the role. And then they'll consider whether procedural fairness has been followed, and you'll remember the arrow that we've put up before. Once they've gone through all of that, the Commission will determine whether they think the dismissal was harsh, unjust, or unreasonable. And if they do think it's harsh, unjust, or unreasonable, they can either reinstate an employee to their position, provide compensation of up to 26 weeks' pay, or reinstate with back pay. And so all of those types of remedies are available if the basis for dismissal doesn't meet that threshold. And remember, it's not just valid reason that the Commission will look at, but the overall circumstances, length of service, parity of treatment with others, procedural fairness, etc., in order to ascertain whether, for a particular employee, the dismissal was harsh, unjust, or unreasonable. Now, I think, Caitlin, you're going to very briefly deal with general protections because I think we're out of time.
Yes. So ultimately, general protections is quite different to unfair dismissal in two respects. Firstly, those exclusions from the unfair dismissal jurisdiction are not relevant. Ultimately, what the general protections jurisdiction tends to also capture is employees who are high earning, they're capped out of the unfair dismissal jurisdiction. And what the general protections jurisdiction ultimately looks at is whether there has been adverse action, whether that be dismissal or another matter relating to the employment, whether that be the person is injured in their employment, there's been discrimination, or they've been prejudiced in another way. And ultimately, what that means is they've been adversely affected in some way because they have exercised a workplace right, undertaken industrial activity, or they have been temporarily absent from the workplace, which we touched on earlier in relation to medical incapacity. And so it's quite broad, and what it lends itself to really, in a sense, is manufactured claims or claims where, ultimately there's historic issues, whether within the employment arrangement, which ultimately were unrelated to the actual reason for termination, but are brought into a claim as part of a general protections claim. Things like whether there is a dispute about someone's work hours regarding flexible work, whether there's a dispute around leave, things like that. Often those things seem to occur in the course of employment, and managers think, okay, well, that's completely irrelevant to ultimately a termination of employment. And in a sense they are, but they often rear their ugly head when it comes to a general protections claim.
And I think, the point here is that if you dismiss someone because they're exercising workplace rights or because they're engaged in these activities, you do have liability. But what we're seeing more and more is managerial employees that don't have access to unfair dismissal laws try and then bring a claim through this prism.
Definitely. And the point that I'd make when it comes to general protections relates to the next slide, and that is that the onus of proof. When it comes to a general protections claim, there is a reverse onus of proof. And what that means is that the prohibited reason does not need to be the only reason, and ultimately the employer is presumed to have acted for the prohibited reason against them unless they can prove otherwise. So as an employer, it's incredibly important that you have adhered to everything that we've spoken about today, that you have documentation to corroborate what the valid reason for termination was, and so that you can rely upon that. Because ultimately, even if you've got a valid reason, if it's not documented, you can end up in a little bit of a pickle here. So it's just incredibly important to ensure, both for unfair dismissals, for general protection's sake, just document everything. Document.
And we've run out of time, so what I want to do is just close off by firstly thanking Caitlin very much for a contribution today. We will have more webcasts to come. We've actually got some training coming up in relation to performance management in July, so feel free to get in touch if you'd like to participate in that. I think it's 2 half-day training sessions. We've also got some overviews of employment law for managers. And finally, for those that have been interested, we have actually got a how-to guide on complying with your positive duty to eliminate sexual harassment from the workplace. People will be aware that there are new laws that impose a positive duty to ensure you're taking all reasonable and proportionate measures to eliminate the possibility of sexual harassment. There's a range of things you need to do to comply with that positive duty. And we've actually set up a toolkit with about 15 different templates that you can use in your business to comply with that. You can give us a call. Someone can do a bit of a demo for you of the toolkit and see if it's something you think would help you in your business. So all of that's available. But for now, thank you for joining us, and thank you, Caitlin.
Thanks, Lewis.